I mean, just looking at the phone can be considered using it.
It seems like that it is the case.
Well, this is intriguing considering that Vic Roads has indicated that you can use your phone as a GPS so long as it is mounted and you're not on your P1 or P2 or you're a learner driver.
And for commercial purposes, that's what Vic Roads says. Well, I have an issue with that. I would not take that as probably as the correct version of the law.
Some of these terms are very vague and can be widely construed, so I just err on the side of caution and
Correct.
not
100%.
look at your phone or use your phone at all. Touch, keep it in your bag, keep it somewhere else in the car so that you're not going to be distracted.
Actually, one of the objectives of this act is to prohibit all probationary driver license holders from using a mobile phone, including a hands-free device whilst driving.
That's an interesting area of law and a good summary of the regulations. But we've got another question to discuss. I got married recently in Australia. I have a ceremony planned with my relatives and friends where I was born, so I gather that's overseas. And as a part of that, there is a registration process. Some of my friends have done it. That is after marrying here to register the relationship in their country of birth. Am I doing anything wrong here?
I don't see a reason why you should be registering a marriage, your marriage again.
It seems a little bit unclear whether they're registering their marriage again or if they're marrying another person.
It may be that they're marrying the same person. They're having the ceremony. As part of that, there is a registration process there. I would say there's no need for that. They could have the ceremony as a cultural thing or a traditional thing. They could invite their friends, but not a legal registration is not required because they are married in one country. It's not required. In fact, if it is another person he is trying to marry overseas, it's bigamy. And the Section 94 of the Marriage Act 1961 says, a person who is married shall not go through a form or ceremony of marriage with any person, and the penalty is imprisonment for 5 years.
5 years?
5 years.
Jeez, okay.
That's
my girlfriend.
What else
can I point this out
say?
as well? Yes, the section have few interesting things. Section 4 of that, a person shall not go through a form or ceremony of marriage with a person who is married, knowing or having reasonable grounds to believe that the latter person is married. So
it goes both ways for the person who
ways.
may already be in a relationship and the person who may not be and is intending to
Correct,
that
yes.
position.
Now this part is probably more relevant to the question. The Section 5 says it is not an offence against this section of a person to go through a form or a ceremony of marriage with that person's own spouse.
So Dinesh, I see the section that you're referring to. It does state that for the purposes of an offence against subsection 1, strict liability applies to the physical element of circumstance, that the person was married when the form or ceremony took place. What does this strict liability mean?
Strict liability, it's mens rea in Latin. That's the intention element. But in this case, Section 6.1 of the Criminal Code is more relevant. That particular section says there are no fault elements for any of the physical elements of the offence, and B, the defence of mistake of fact under Section 9.2 is available. So it is a defence to a strict liability offence if it's a mistake of fact. Now, to understand what that is quite important as well.
So how do we get a sense of what that is then?
If we continue to read the rest of the sections, Section 2, it is a defence to a prosecution for an offence against subsection 1 if the defendant proves that at the time of the alleged offence, that's bigamy, the defendant believed that his or her spouse was dead. So that's a fact.
Wow.
So if he believes. And the defendant's spouse had been absent from the defendant for such a time and in such circumstances as to provide, at the time of the alleged offence, that's bigamy, reasonable grounds for presuming the defendant's spouse was dead.
So could this be in instances where someone's gotten lost? Say, for example, in the woods for 10 years, let's say.
It's actually talking about a situation where the spouse is dead, and if that is a fact, or on reasonable grounds assuming that is the case, then that is a fact, and it is a defence for bigamy.
But the defence says that the defendant believed, so the person may not actually be dead, it's just the belief that they were dead.
So they could still be lost in the woods.
Correct, yes. In practical sense, it may be the case, yes.
Are there any other defences available under this section?
Number 3 says, for the purpose of the subsection 2, proof of a defendant that a defendant's spouse has been continually absent from the defendant for a period of 7 years immediately preceding the date of the alleged offence, and that at the time of the alleged offence, the defendant has no reason to believe that the defendant's spouse had been alive at any time within that period, is sufficient proof.
So these defences really come down to the death of one of the parties involved in that relationship, which is just so major. I wonder whether there's anything else in law that would allow would be considered as a defence.